Your neighbor paved over their entire backyard, and now every time it rains, your yard turns into a swamp. Ever wonder whether your neighbor is actually allowed to do that, and whether you have any real recourse? Today I'll explain property drainage law like you're 5 years old. By the end, you'll know exactly who's legally responsible and what you can force them to pay for. You'll also learn the one move most people never make that completely flips this situation in your favor. Quick note. This is legal education, not legal advice. Laws vary by state, so check your local rules or talk to a property attorney. Here's the situation. Your neighbor decided to pave over their lawn, and it's now destroying your yard. Maybe they wanted a bigger driveway, or maybe they just hate mowing. Whatever the reason, they covered every inch of dirt with concrete or asphalt. And now, every single rainstorm sends a river of water directly into your yard. Your grass is dead, and your basement is constantly wet. You've got standing water creeping toward your foundation, and your neighbor is looking at you like you're the problem. Thousands of people are dealing with this exact thing right now. So before you knock on that fence, let's talk about what's actually happening. There's some physics involved that the law cares about more than you'd think. Dirt absorbs water. Think of your neighbor's old lawn like a giant sponge. When it rained, that sponge soaked up a huge percentage of the water. Some evaporated, some soaked slowly into the ground, and only a tiny bit ran off. But then they paved it, and now that sponge is completely gone. It's been replaced by a concrete sheet that sends 100% of the water somewhere else. And that somewhere else is your yard. Not a neighbor down the street, not a storm drain. Your yard. Here's where the law gets interesting, and most people don't know this part. Most states have what's called the reasonable use rule for surface water. But here's the part nobody tells you. The baseline rule in most states is actually that water flows downhill, and that's just life. If your yard sits lower than your neighbor's and rainwater naturally flows toward you, the original common law said that was basically your problem. It's called the civil law rule, and it treated water like gravity, something you just have to deal with. That might sound fair, but it's actually not the whole story. Most states have moved away from that old rule, and the update is significant. The modern standard, called the reasonable use doctrine, says your neighbor cannot take actions that substantially and unreasonably increase the flow of water onto your property. The key word there is substantially, and paving over an entire yard almost certainly qualifies. The law isn't protecting gravity anymore. It's protecting you from your neighbor making the problem dramatically worse than nature ever intended. There's still a catch, though. And this is the part that makes people want to flip a table. Even under the reasonable use rule, you don't automatically win. You have to prove 3 specific things. 1. Your neighbor made a change to their property. 2. That change increased the water flow onto yours. 3. You suffered actual damages because of it. That third one matters. Frustration isn't damages. A soggy lawn for a day isn't damages. But a flooded basement? Dead landscaping you paid to install? A cracked foundation? A mold problem growing behind your drywall? Now you're talking about real numbers and real legal leverage. Imagine their lawyer sending you a 2-line email. It basically says, prove it. Because that's exactly what they'll say. And most people can't because they never documented anything. We'll come back to that. Before we get to what you can actually do, I need to tell you about the move your neighbor is quietly hoping you never find out. Because some of them know exactly what they did. They didn't hire a contractor who accidentally sloped the concrete toward your yard. They designed it that way. Cheaper drainage, less work on their end, your problem to absorb. And here's why that matters legally. Intent changes everything. When your neighbor deliberately angles drainage toward your property, that's not just negligence. It can become an intentional tort, a legal term for when someone causes harm on purpose. In some states, intentional diversion of water opens the door to punitive damages. That's money beyond your actual losses. Money the court awards specifically to punish the behavior. So the neighbor who thought they were saving $500 on a French drain? They may have just handed you leverage worth several thousand. Their plan depended on you not knowing that. Now you do. Okay, let's talk about municipal codes. Because this is where most of these cases actually get resolved. Without a single lawyer.
Most cities and counties have local stormwater or drainage ordinances. These rules say, essentially, you cannot direct increased stormwater runoff onto your neighbor's property. Full stop. These aren't just guidelines. They're enforceable local laws. And here's the beautiful part. You don't have to sue anyone to use them.
You call your city's code enforcement office. They come out. They look at the drainage pattern. If your neighbor violated the ordinance, they get cited, sometimes fined, sometimes ordered to install drainage infrastructure at their own expense. Picture this. The code enforcement officer walks your property line and looks at the slope of that concrete. She pulls up the permit file, or notices there isn't one, and she writes your neighbor a notice that basically says, "Fix it, or we fine you every single day until you do." Your neighbor didn't just upset you, they upset the city. And the city has a lot more leverage than you do. This is the move most people skip. They go straight to yelling, or straight to a lawyer, and they miss the free tool sitting right there. A code enforcement complaint costs you nothing and creates an official record. And if the city finds a violation, that finding becomes evidence if you later pursue a civil claim. Now let's talk about what you're actually owed if this goes further. In a civil lawsuit for improper water diversion, which is a real cause of action in most states, you can potentially recover the cost to repair whatever got damaged. Foundation work, flooded basement restoration, landscaping, retaining walls. In some states, you can also pursue something called nuisance, which is exactly what it sounds like. Your neighbor created a condition that substantially interferes with your use and enjoyment of your own property. Courts take that seriously. Juries take it personally. Here's the part that surprises most people. You can also pursue injunctive relief. That's just a legal way of saying you ask the court to order your neighbor to fix the problem. Not just pay for your damages, actually install proper drainage so it stops happening. That's a court order. If they ignore it, that's contempt of court. Suddenly your neighbor has a much bigger problem than a paving bill. Their concrete isn't going anywhere, but a judge can absolutely make them put a drain in. Here's what you now know. Old common law said water flowing downhill was simply your problem to deal with. The modern reasonable use doctrine says your neighbor can't deliberately make it worse. Intentional diversion can escalate to punitive damages territory, and your city's stormwater codes are often the fastest and completely free way to hold them accountable before you ever talk to a lawyer. Here's what you do. First, document everything. Photos with timestamps, video of water flow during an actual rainstorm, written records of every incident. This is your evidence, and you need it before anything else. Second, find your local municipal code for stormwater or drainage ordinances. Your city's website usually has this. Third, file a code enforcement complaint. Free, official, creates a paper trail. Fourth, send your neighbor a written notice, not a threat. A factual letter that says, "Since you paved your yard, I have experienced flooding on these specific dates, causing this specific damage." Keep a copy of everything. Fifth, if the damage is significant and code enforcement doesn't resolve it, consult a property attorney. Many handle these cases on contingency, meaning they only get paid if you win. Your neighbor paved their yard and made your problem worse, by negligence or by design. Either way, the law gives you tools. Most people never use them because nobody explained what those tools were. Now you have something your neighbor was counting on you never finding. The exact playbook they were hoping you'd never see. Here's the question I'll leave you with. Your city can cite your neighbor for bad drainage after the damage is done. So why don't they check for violations automatically when the paving permit gets pulled? Drop your answer below. Because I think it says a lot about who the system is actually designed to protect.